Hello, I hope you're not sleeping. So first and foremost, I want to take this opportunity to thank the organizer, the International Safeguarding Committee, for having me here, particularly Father Hans for inviting me here. Thank you. I traveled all the way from the Philippines, almost 18 hours, just to be here with you. I hope you will get something out of the things that I'm going to share with you this afternoon. So we listened to Mrs. Capoche, and she really said that sexual violence against children is a global problem, and it should be addressed globally. Precisely, that's why we are here. Lanzarote Convention offers guidance and inspiration, just as we have heard from her, for any government in the world wishing to address this serious problem by its strengthening its legal framework. The Philippines, although it's not a party to the convention, more or less we subscribed to what Lanzarote Convention proposed, and that is a holistic approach to child abuse, to handling child abuse cases. The Philippines, to be sure, is and remains to be a relatively friendly country, child-friendly country rather, at least its laws are, because we ratified the United Nations Convention of the Rights of the Child in 1990. Following the ratification of the UNCRC, Philippine Congress cannot but passed a law that is of international standard in accordance with the United Nations Convention of the Rights of the Child standard. Also, the Philippines, you will really see that it has already a safeguarding or a provision under the Constitution that would protect children. We have, under our Constitution, states that the right of children to assistance, including proper care and nutrition and special protection from all forms of neglect, abuse, cruelty, exploitation, and other conditions prejudicial to their development. The state also recognizes the vital role of the youth in nation building and shall promote and protect its physical, social, moral well-being. So following the passage of after we have ratified the convention, we passed a law, which is it has a long title, which is an act providing for stronger deterrence and special protection against child abuse, exploitation, and discrimination, and providing penalties for its violation and for other purposes. And we called it, in short, the Anti-Child Abuse Law, or the Republic Act 7610. Up until the present, it's still the principal and law and most comprehensive that is geared towards the protection of children. But other laws follows thereafter for the protection also of children, such as the Anti-Trafficking Act, the Child Anti-Pornography Act, the Anti-Child Labor Law, and many others. In our jurisdiction, in our law, child is defined in two ways. One is that a child is below 18 years of age. Second definition, a child is considered a child even if she has reached the age of maturity, which is 18 years old. 18 years old or above 18 years old, so 50 years old, 60 years old, can still be a child, provided that this person, he or she, cannot fully take care of herself or fully protect herself from any form of abuse, discrimination, or exploitation because of her physical and mental disability. So we have two definitions of what a child is. So as modern types of abuse against children were better understood, the Philippines recognized that it would take a whole government approach to reduce child abuse. So while you listen to the speech of Mrs. Capoche, she mentioned that the convention, Lanzarote Convention, created a monitoring mechanism, which she calls as the committee to monitor the compliance of European states in what was taken up in the convention, the Lanzarote Convention. So this committee really examines the implementation of what was taken up in the Lanzarote Convention. Also, in the Philippines, since we recognize that it will take the whole government, it will take a government approach so that the government also through an executive order passed by our president, issued what we call as the committee, a special committee for the protection of children, which is composed of the different government agencies, such as the Department of Justice, which is the lead agency where I come from, where I work, the Department of Social Welfare and Development, the Department of Labor, the Philippine National Police, the National Bureau of Investigation, the Department of Immigration, and many others. And it's not only the government agencies involved in this committee, but also, as what Ms. Capochi mentioned, very important is the participation of non-government organizations. So non-government organizations are also involved here. And in this committee, after the creation of this committee by the president through an executive order, also passed and issued a protocol, which is, I think, very important for us. And this is the protocol for case management of child victim of abuse, neglect, and exploitation for the guidance of all concerned government agencies, non-government organizations, and other stakeholders. The Department of Justice, as the lead agency, is in the forefront of the fight against child abuse in our country. As prosecutor of the Department of Justice, I get to interact with children sexually exploited, and over the course of dealing with these victims, I have some insights on the institutional challenges that victims encounter in reporting the abuse. I'm going to talk about these institutional challenges from the perspective of a prosecutor. Victims of sexual abuse, be it a child or adult, have same thing in common in reference to the abuse, although the behavioral responses vary. One basic concept in understanding a child's competence and behavior towards abuse is the impact of the victimization of the child in the different stages of the child's development. I know I'm not competent to talk about this because I'm not a psychologist. I'm not an expert of the child's developmental stage and how the behavior of a child in the different stages of his or her development. However, I would like to tell you that we get trainings. We have in the Philippines an annual competency enhancement training for prosecutors, judges, law enforcement, and social workers, those handling child abuse cases. In this training, we get to interact. We get to have some exchange of ideas, and we get to be trained also by experts so that we are educated and we understand why a child behaved the way she does. So when I was telling you about the protocol that we have, which is already established, the protocol in handling child abuse cases, that's why I was talking to my friend from the US and I was saying that this protocol that we have in handling child abuse should not supplant the protocol of the church. So that when an information is received by the authorities about child abuse, immediately we have already the procedure what we have to do with the victim. And as a prosecutor, it's very important and very crucial that stage when there is a report that is received by us, an information, because we have an interest on the case, in the prosecution of the case. Now, if the church would interfere with the investigation, would not submit the child to us, and we know already the process of what we're going to do when there is a reporting of abuse. Instead, they will interfere. What will happen here? It would be difficult to prosecute because we are not only interested in the child's testimony, we are also interested in the other evidence. Do you have a digital evidence? Do you have a text messages in your cell phone? That is something very important for us. So that's why you have to submit the child to us. As I said, it's already established. We know what to do with the child. And also, very important is when the social worker mandated by law to really assist the child, assess and determine whether or not there is a need for rescue, There is a need to take protective custody of the child and put the child in the center. That is her mandated job. So that's why very important that when we receive the information of abuse, where the child will be taken, you know. Whereas if you just do it on your own, who knows that the evidence is already tampered and we cannot do anything anymore. We cannot prosecute the case because evidence has been tampered. And you know, evidence like digital evidence. And in the taking of the testimony, someone who is expert to take a forensic interview and the child must do it. However, during our competency training, we are also trained to interview a child just in case we are the one who had the initial contact with the child. Excuse me, can I drink water? So, in our jurisdiction, we recognize what is called as the concept of child sexual abuse accommodation syndrome. The court has recognized that CAAS. What is child sexual abuse accommodation syndrome? It refers to, or it is a description of a set of behaviors that can explain how or sexually abused child views the abuse and try to survive and try to cope or attempt to cope with the abuse. For us in our jurisdiction, we do not use the CAAS as a tool to establish the guilt of the accused beyond reasonable doubt. But rather, for us prosecutors, it is a tool for us to explain why the child behaved the way she does. Because sometimes the credibility of the child during trial is being challenged. The child is not credible, so it's being challenged. So this is now where we present a rebuttal evidence of an expert who could explain why the child behaved the way she does. So that's the child sexual accommodation syndrome. The institutional challenges in reporting of victims who are abused is that sexually abused child may not disclose immediately or not at all because she feels ashamed, confusion, or fears that she will not be believed. If the abuser has threatened her or him, the child may fear repercussions or fear the abuser will hurt other family members. She may be too young to understand the wrongfulness of the abuser's act, or she may suppress the whole experience. And under the child sexual abuse accommodation syndrome, the one who proposed this, a clinical psychologist from UCLA, he said that there are 5 stages that the child undergo in a child sexual abuse accommodation syndrome, and that is secrecy, helplessness, entrapment and accommodation, delayed in reporting, and retraction. So these really are our institutional challenge when a child has what is afflicted with CAAS. Secrecy, especially when the perpetrator will tell her, let's keep this a secret, let's keep this our little secret. And if you disclose this secret, you will have a negative consequence. Helplessness, sometimes they would feel helpless. They don't know what to do because there is an imbalance of power between the perpetrator and the child. And so the child sometimes does not know how to stop the continuing abuse. Then she feels trapped. And so also there is a delay in reporting of cases because of this. And most importantly, which I always encounter in my job, is retraction. Retraction. So okay, the child has already testified, she already executed an affidavit, and everything is in place. And when she will be presented, time for her to be presented in court, she will recant. He would desist. He would change her story. So that's the challenge for us. If the child is afflicted by CAAS, recantation is sometimes really 99%, especially if the child is not in the custody of the Department of Social Work and Development, or she is not in the shelter. That's why I said from the time that there was a report that we received of abuse, then we determine that there is a need to take protective custody of the child or to file a petition for involuntary commitment of the child in a shelter. Because, you know, it's really given that if the child remains in that environment where the abuser is situated, she will be influenced not to pursue with the case. She will be influenced to also, you know, she will be silenced by people around her. And that is what usually happens. And also the court noted and recognized the CSAAS in many cases, in many jurisprudence that it passed. Example, the Supreme Court said, if the sexual abuse has been taking place for a long time, the child may develop rage and anger towards her parents, rather, and it's possible that the child is in turmoil and conflicted, especially if she becomes the center of attention of the family and the source of stress. The disclosure may cause economic problems, thus she will be prompted to retract her statement and lie about the abuse to preserve the peace. If the child is not supported, if they are hostile to her due to her disclosure, recantation can be seen as the only option for peace and return of love and support of her family. So you see, it's not only reporting that is the challenge, but even if she reported already, she would recant and change her story, or her testimony would be inconsistent. But the Supreme Court said in some cases that delay in reporting rape incidents in the face of threats of physical violence cannot be taken against the victim. So a rape victim's action is oftentimes overwhelmed by fear rather than by reason. So it is this fear springing from the initial rape that the perpetrator hopes to build up a climate of extreme psychological terror, which would, he hopes, numb his victim into silence and submissiveness. That is People versus Milive. So these are really our challenges in the field, why there is a delay. But however, because of our continuing education among judges and prosecutors, that what I called as the enhancement competency training on and then we get to understand and try to address this particular problem. In fact, the Supreme Court passed the rules on examination of child witness, which could really help, which is child-friendly rules that could really help in the prosecution. Like, for example, it developed an evidence that is not victim-dependent. So for us, the challenge is, what if the victim during trial is already sick or so traumatized to testify? What will happen? So that is our concern. So under the rule of the examination of child witness, a videotape deposition can be taken. The child can be declared an available witness, and another witness, like for example, a psychologist, that is an hearsay evidence, but in the rule of examination of child witness, it admits hearsay evidence subject to exception, of course, subject to requirements provided for in the rules. So like there must be the statement must be corroborated, etc. So what else? We have this rule of examination of child witness is really something child-friendly. Like for example, it allows the introduction of an anatomical doll during trial, an anatomical doll which would help demonstrate how the abuse was committed. So there is a demonstrative aid that is provided, and it also admits guardian ad litem, the appointment of the court of a guardian ad litem as a support for the child. And we have also what we call a Kitty Cap program in our country, which is the Teens Court Awareness Program. So before the kid is taken to the courtroom, before that, then there will be a program that will make her be acquainted and be familiarized with the court personnel and the court and the judicial proceedings. So these are the steps that we are really taking with regards to cases involving sexual exploitation and abuse. So that in the case of priests who committed sexual violence, I really pray that the child would be referred to us immediately, because we have already an established protocol. So why does the church need another one when the government itself, the authorities itself, has already in time even worked on it? Try to address the issues, the challenges. So before I end, I would like to share to you a story of my friend. He is a lawyer already, but he was abused when he was still an altar boy. He was a teenager. So this friend of mine, will just call him Raul. He was an altar boy in a big, known archdiocese in my country. And then one day, he was with another altar boy, and they were taken by the priest to a movie house to watch movie. And what happened there, you can just imagine, the priest was seated in between these two boys, and something happened that night. And so he said he was initiated to something that he was not ready, and it really damaged him and also the other altar boy. And then what happened was, he reported this matter to the authorities. He was so brave enough, but this is what I would like to share to you, his difficulties that he encountered when he reported the abuse. He said, I will quote this because he really wrote this, and he would really told me that, Liza, please share my story. Maybe it would help in that gathering that you'll be attending. He said, since the perpetrator is a priest, I was subjected to scrutiny, particularly on my motive. In my case, even my lifestyle, choice of clothes, and appearance was not spared. In school, my religion teachers and even others would try to talk me and dissuade me from pursuing with my complaint filed with the prosecution's office. One time in my class, in religious education class, the teacher scolded me. When she saw that I did not join in singing the song in class, she then approached me and lectured me about doing something in my life rather than spending time ruining people. Then another time, distant relatives suddenly expressed concern and started paying me a visit to get first-hand information on my case that I filed against the priest. It turned out that some of them were approached by influential members of their parish, either rebuking them for their association with me or asking them to convince me not to pursue with my case against the priest. When I landed my first job out of college, the business owner forced me to tender my resignation when he discovered that I was the one who complained about a priest. The mechanism from within the church is run by clergies whose objectivity is questionable. In my case, the church's investigation included therapy counseling component that focuses heavily on forgiveness and moving forward. When I shared that I am open to such, but that this openness does not include withdrawing my complaint, I was told, bahala ka na gahi ka og ulo. That's in dialect, which means it's up to you. We don't have anything to do with you anymore. You are hard-headed, something to that effect. And the therapy was stopped. Other church organizations would not let me, including those associated with me, join in their organization when they learned about my complaint filed against the priest. On the legal aspect, I encountered setbacks after setbacks, as even if the perpetrator has already admitted to the acts I complained of, the case was still dismissed. According to the Philippine Statistics Office, our statistics office, about 8 out of 10 of the household population in the Philippines are Roman Catholics. So priests, still really highly regarded. It is like someone who cannot do wrong, as heinous as like abusing a child. In some cases like this, it's the community of believers themselves that protect the priest and even blame the victim, reversing the situation, making it appear that the child victim is the one guilty of spreading lies. There is indeed an imbalance of power because we see priests as person of authority, more so if the bishop or cardinal would side with the priest. There has to be a paradigm shift to look at the sexual violation of a child or vulnerable adult in the perspective that it's not about a priest or priesthood. No, it is about a criminal. It's about a sex offender. It's about a pedophile hiding behind a cloak of respectability and using the church to perpetuate his evil intention. Lastly, clergies who are not in this category should be aware of the gravity of the offense committed by their fellow priest, and they should not be complicit, and should develop and awaken in them, in their consciousness, in their conscience, a sense of justice. Thank you. And